Good evening, ladies and gentlemen. Law Essentials welcomes you to the 13th edition of the webinar on Right to Information in Indian Democracy. We have with us today Advocate Prakash Upadyay. He is an advocate at the Madhya Pradesh High Court. He is a pass out from the NLIU Bhopal. Over to you, sir.
Thank you, Farhan. First of all, good evening to all, and I thanks Law Essential for giving me opportunity to address on this issue. Now, today we are discussing this right to information in Indian democracy. As the topic itself explained, that we are dealing with the aspect of divulging information in the Indian democratic establishment, particularly election. Now, right to information, as I like to say, that it's more about right to knowledge or right to know. There is a basic difference. What I see that there is a basic difference between knowledge and information, because I perceive knowledge to be a refined information that is relevant and objective information that helps a person to draw a conclusion. So since it's a concept which is developed by Indian judiciary, so it conceived somewhere in the year 1975 by the Indian court. It has been, I must say that it has been delivered concretely by the Supreme Court in the year 2002, and thereafter it was developed. So what I propose, that first a brief description about the democracy and the role of information in that democracy, and thereafter we will proceed with the development of concept of right to know in the democratic setup, Indian democratic setup. So as we all are aware about the fact that democracy is basically a government by the people. There are two forms of democracy. The first one is the direct democracy, where the people themselves, they collect and themselves decide the vital issue of governance. This form of democracy is rarely followed. We have only the Switzerland as a country which practices it at national level. In India also, we have this concept of direct democracy at Gram Panchayat level at some states. Now, if we talk about the Indian scenario, basically we follow a representative form of government where the people, the electorate, they represent, they elect their representative, and these representative, the member of the parliament, legislative assembly, they represent the will of the people in the parliament, and they decide the policy of governance. Now, this particular democratic setup we are following at every level, whether it is the Gram Panchayat level, whether it is a municipal or state or national level. So, India basically is a democratic country, and in any democratic country, to govern, the opinion of public is important, because any government cannot function unless it has a support of people. And for getting a support of people, definitely the public opinion is very important. Now, what is the process of forming a public opinion? How we decide that whether something is good or something is bad? How we are going to decide that whether the performance of our leader or the policies of the government is good or not? Definitely, they are always a public opinion is formed in form of discussion and debate, expression of views, everything unless and until so these are the process of forming a public opinion. And to have a fruitful discussion, we all know that knowledge or information plays a very important role. We cannot discuss an idea, we cannot discuss an issue unless and until we know that what it is about. So in order to function for any democracy, in order to function, a well-informed citizenry means that the electorates of that particular democratic setup should also be well-informed. Now here the actual role of knowledge come in picture. Now, because it helps to form a public opinion, and that is the reason why we see that there is a struggle between the person who in power to control this particular knowledge, because it is a this knowledge is a stream of it's like a blood stream of a democracy. Therefore, if you control this particular knowledge, definitely you will control the opinion of the people, and that will help you to formulate your policy, to get a support, or to oppose the policy, any of the policy. Now, it is always, since once we have adopted a democratic setup, so it is the responsibility, it is equal responsibility of parliament and legislature of the country to keep the people informed. So it's the concept is that the maximum disclosure is always encouraged in any democratic setup, and secrecy is definitely it is a necessary evil, because we cannot have everything in public. There are area like every right we have, there are area of restriction also. So there are area like defense, foreign policy, or etc., where the government can have secrecy. But it is always insisted that the people of the country should know maximum, should have a maximum disclosure about affair of the state to them, affairs of the state. Now, it is a right of people. In an anti-democratic setup, it is a right of people. But unfortunately, when we see our legislative history, this particular right has not been formally recognized in any of specific legislation. I am not talking about Right to Information Act, which has been formulated and enforced in the year 2005. But prior to that, this particular right was not having any specific concrete recognition. Now, this particular right has been basically developed by Indian judiciary, and the first instance I found in the reported judgments was State of UP versus Raj Narayan, which has been reported in 1975, Volume 4, SCC 428. Now, this is as I said in the starting of this particular webinar, that the idea of right to know that has been conceived initially in 1975. So this is the judgment where where the Supreme Court, Honorable Supreme Court, has conceived this particular right to know, and they have in fact established, they have recognized that this right to know is linked with the freedom of speech and expression, which has been entrusted to us under Article 19 of the Constitution of India. Now, I give you a brief background of this particular fact, that Mr. Raj Narayan used to contest election against the then Prime Minister Srimati Indira Gandhi. So obviously the Indira Gandhi was the winning candidate. So Mr. Raj Narayan has filed a election petition where he has alleged certain kind of corrupt practice, and including the misuse of power. So during the course of election petition, he has filed an application before the High Court, since the election petition are tried by the High Court. The High Court act as a trial court. So he has filed an application before the High Court for summoning certain document relating to standard procedure, which is connected to the PM security. The state definitely has claimed privilege over that particular document, but the High Court has not accepted it, and the verdict goes in favor of Raj Narayan, and it has been ordered that this particular document shall be summoned and will be proved before the court. Now, with this particular order, the state of Uttar Pradesh has preferred appeal before Supreme Court, SLP before Supreme Court. Now, when this SLP came to hearing, though ultimate conclusion was against Mr. Raj Narayan, the court has ruled in favor of non-disclosure. But there was a very interesting argument, observation made by one of the justices, that is Justice K.K. Matthew. This is very important judgment, because this judgment has, in future, it has laid the foundation of this development of this right. So Justice Matthew, K.K. Matthew, while providing reason for non-disclosure, he has dealt with this aspect of right to know. And he has said that we have a freedom of speech and expression under Article 19 of the Constitution. So to exercise this particular freedom, right to know is a very important right, and we can very safely read this particular right in the fundamental right of freedom of speech and expression. And the court has also recognized this particular fact that the routine secrecy in the matter of governance is not desirable, and if and the government should not insist for secrecy in its routine business. And for any responsible government who are acting as an agent of public, who are governing on behalf of public, it is their sacrosanct responsibility to disclose to public their affairs, and there can only be few secrets. Now, this was a concept, though it was developed, it was echoed in this particular judgment. But actually, we have got nothing, because still there was an era of secrecy, and everything was going the same way. It remains in law book. Now, to some extent, this freedom was, though the legislature has always favored towards secrecy. It has not encouraged the disclosure, but to some extent, there was a certain development that in the year 1989 there was a decision by the government to telecast the parliament proceeding, the address of the then president to both houses of the parliament. They were telecast. From 1994 onward, there was a selective telecast of the parliament proceedings. From 2004 onward, we have a dedicated channels which telecast the proceedings. So it has, to some extent, it has educated people about the affairs of the government, what is going on in the parliament, and it has helped us to know the performance and the issues which are being and the business of our representative of the parliament. Now, 1990s was an era also where we have seen the dawn of the cable television. There was a 24-hour news channel. So here the media come in picture, and they have these news channel. They have started picking up the issues. Some real issues were highlighted, and one of the issue which came for consideration was in the year 1995. Now, we have seen that the major changes. It is very interesting thing that the Indian legislative history or judiciary, to have a major change, there has to be a major issue also. Either some high-profile person is involved who can afford a good voice, a decent lawyer who can properly represent it, or the issue is such. So, in the month of July 1995, there was a famous activist, Naina Sahni, who was murdered, and the prime accused was politician. Now, this has definitely caused an unrest amongst the people. The newspaper reports were published. The media channels, the news channels, they have highlighted the issue, but they have not restricted themselves to the issue of murder, but they have also highlighted the issue, the growing number of the person with criminal background who are joining politics and holding a key position, an important position, not only in the parliament, but also in the party politics of the various political parties. So the public, it came to the public opinion, public discussion. So the parliament was compelled to put certain reports, to table certain report, and one of the report was Vohra committee report. Actually, Vohra committee was constituted on this particular issue. Its report was with the government, but the government was not making it public. So it has compelled the government to put this particular Vohra committee report tabled in the parliament, and there was an extensive discussion. One Mr. Dinesh Trivedi, who was a parliamentarian, he participated in the debate, but he was not satisfied with the fact that only the summary or the finding of the report, which is put before the parliament, the other document, the excerpt to that particular reports were never placed before the parliament, and they were not made public. So he has filed a petition before Supreme Court demanding for these document, and and his contention was that the content of the report was such that the government do not want to disclose it. So it's my right, and it should be provided. Now here, the Supreme Court, while adjudicating this particular issue, they have definitely relied upon this Rajnarayan judgment, which we have discussed earlier, and it has observed that in order to ensure a continued participation of people in democratic process, they must be kept informed of the vital decision taken by government and the basis thereof. The democracy thereof expect openness, and openness is complement of free society. Sunlight is the best disinfectant. But if it is equally important to be alive to the danger of lie ahead, it is important to realize that undue popular pressure brought to bear on the decision making in the government can leave a fatal side effect. If every action taken by the political or executive functionary is transformed into public controversy and made subject to an inquiry to soothe popular sentiment, it will undoubtedly have a chilling effect on the independence of the decision maker, who may find it safer not to take decision. It will paralyze the entire system and bring it to grinding halt. So we have two conflicting situations that is almost inevitable, which we think that the answer is to maintain a fine balance which would serve the public interest. So here the government was examining, here the court was examining about the two conflicting issues. That one issue is that openness in the government, and second issue to draw a balance between balance of fair and independent governance. So the court has said that it is a vital concept, and it has to be recognized. Now there was but this particular issue of criminalization of politics that was gaining momentum. So there was a law commission report also, that is 170th law commission report, which has dealt with this particular issue of criminalization of politics. And one of the measures which was suggested that that in order to control these criminals from entering into the arena of parliament, people should made aware about the background and the other aspect of a candidate which is contesting election. But for reason best known to the government, this particular report, 170th Law Commission report, that was never seen the light, and it was never put before the parliament for discussion. So there was one NGO, which is Association for Democratic Reform and other. They have filed a petition before Delhi High Court. Their petition before High Court of Delhi was basically for implementation of the recommendation of 170th report of Law Commission. So Law Commission, I have already stated that Law Commission has undertaken this particular task. It has not only dealt with the menace, but also has suggested certain measures by which this particular aspect can be controlled. Now, one of the suggestion was that the candidate, the present law is not dealing, because it is waiting for conviction of a candidate to debar him for contesting election. So one of the suggestion was that the candidate who has been charged for a certain offense, then they should be disentitled for contesting election. And there was other suggestion with respect to the disclosure of the criminal antecedents, the assets owned by the candidate, dependent, and spouse. Now, the Delhi High Court has considered the issue. They have relied upon that Rajnarayan judgment, which has said that, which has linked this right to know with the fundamental right under Article 19(1)(a) of the Constitution of India. And they said that since it is a fundamental right of a voter to know about his candidate, therefore they have a fundamental right to know about the information regarding the criminal activity of candidate, so that they can make a right choice. Because if we know, they are of the view that this particular information is in exclusive possession and knowledge of a particular candidate. So it has to be brought to public. So they have issued a direction to Election Commission of India, and the direction was to secure the following information. The first was conviction for any offense. The second was the assets of the candidate and dependents, and third was the fact which which the election commission feels necessary, and necessary for judging the capacity or competence of the candidate, which also hello. So it has basically education qualification and information which is necessary for the judging the capacity of the candidate. Now, very interestingly, though it was pro disclosure, the Union of India, it is not an order against the Union of India, but Union of India decided to challenge it. And the ground of challenge is very interesting. The first ground is obvious, that the High Court do not have power to issue such kind of direction, because there is no express provision under any act which provides for such kind of disclosure. And it is for political parties and parliament to take decision or to make a suitable amendment in Representation of People Act and other laws governing such disclosure. And there is no disclosure for no disqualification for non-disclosure. So non-compliance will not attract. And the second argument which take, that though the High Court has made a certain observation direction with respect to the disclosure, but it has not prescribed any consequence for non-disclosure. So it's a basically toothless tiger, because even if we do not comply, if any candidate do not comply with this direction, he will not attract any kind of disqualification. Now, there was one intervener, there was one political party. Their argument was also very interesting. They said that this particular, the education qualification and the assets, they are futile information, because in India, most of the voters are illiterate and they have nothing to do with the affairs, the private affairs of the candidate. So this is a futile exercise which the High Court is undertaking, and that is not required. And people are not interested in knowing the wealth or property detail, and it is job of the parliament to stop the criminal. It should not be undertaken by the court. Now, the Supreme Court, Honorable Supreme Court, while dealing with this issue, has dealt with the aspect of importance of education to voter, right to know. Again, this concept of right to know was discussed. Right to know was again linked with the free and fair election, and it has linked with basically education of voter. The court has the court has taken care of this particular argument that voters are not interested in the background of the candidate. Honorable Supreme Court has held that even it's our responsibility to educate the voter, and even an illiterate voter need to know education to be educated, so that he can participate, he can effectively participate and vote while exercising his or her own criteria. So he need to be educated about the candidate, and thereafter he will exercise his free and his choice of vote with respect to candidate. Now, it is voter. It is, you cannot take a decision that what is important. It is voter to decide, and therefore, for any healthy democracy, it is necessary that voters should be informed about contesting candidate. They have all the relevant they have all the relevant information about the candidate, so that they can decide that whether this particular person is actually eligible to represent them or not. Now, there was an argument that court does not have power to pass such kind of direction. So to deal with that, the Honorable Supreme Court has taken the shelter of Article 324 of the Constitution of India, which is a provision dealing with the superintendent's direction and control of election by election commission. The court has, while reading this particular right to know as freedom of speech and expression, the court has said that in order to ensure a free and fair election, it is equally important that public must know the every public act which is done by public functionaries, including the MP and MLA. And therefore, public education is essential for functioning of popular government. And decision making, when the person decide that whom he or she need to vote, definitely he she deserve all the relevant information about that candidate, because without that information, he or she cannot exercise his right to vote freely and fairly. Now, the court has also taken the note of, there was an argument by one political party who has appeared as intervener that this will not be able to break the vicious circle which has polluted the democracy. The court has said that yes, we know that this particular step is not going to make any drastic change, but it is just a step in it. It is a baby step toward the reform. And it has expressed a hope upon the voter that once they know that their elected candidate, the candidate which is going to represent who is seeking their vote, he is a lawbreaker. So the court ensured that they will definitely would not like to make a lawbreaker as a lawmaker, and definitely some improvement is going to be. So there was a direction issued to the election commission to issue necessary instructions for disclosure at the time of filing nomination paper. Now, this judgment which we are discussing, that has been passed in the month of May 2002, that is 2nd May 2002. And within 3 months, the Parliament purportedly, particularly Parliament, not the government, purportedly to comply with it. There was also a direction to the government that since there is a no law governing this particular issue, so the court is exercising its extraordinary legislative power, and it was requested from the government to fill that particular lacuna by introducing suitable amendment or by bringing legislation to that effect, like the court has done for Vishakha and other cases with respect to the sexual harassment. Now, purportedly to comply with this particular direction, within 3 months, that is on 24/8/2002, the central government came with a Representation of People Act Amendment Ordinance, which has been later on replaced with RPA Third Amendment Act 2002 on December 28, 2002. Now, they have inserted 2 provisions in the Representation of People Act, that is Section 33A and 33B. Now, this 33A was with respect to, it has in fact diluted the observation which was made by the Honorable Supreme Court in this matter, Association of Democratic Republic matter. So they have just the provision says that the person is required to disclose the offences in which they have been charged for a conviction for a period of where the conviction is 2 years or more, and some other provision, and it does not talk about the disclosure of education qualification, the disclosure of assets and other things. That is one aspect. The very interesting provision was 33B. Now, 33B of Representation of People Act, that in fact says that the disclosure, the candidate is only bound to make a disclosure prescribed under Section 33A, and no other disclosure is required. So what the Parliament has tried to do is to nullify the other suggestion, other directions given by Honorable Supreme Court, and also the consequential circular or the direction issued by Election Commission in compliance of that particular order. Now, this particular amendment, particularly 33B of this Representation of People Act, that was challenged by the People Union of Civil Liberty in the year 2003. And they say that 33B, this insertion of 33B of representative of in the representation of people act is basically violative of fundamental right of citizen of country, because it has already been held by Supreme Court in 2-3 cases, including this Rajnarayan matter and Association for Democratic ADR matter, that it is right to know is a fundamental right. So this particular 33B is in fact violative of fundamental right, because this right to know is derived from Article 19(1)(a) of the Constitution of India. Now, the reply of the Union of India in this matter was very interesting. The Union of India came up with a reply that it was, in fact, these particular amendment is satisfying the direction which are given by Honorable Supreme Court in earlier matter. And second aspect is that this fundamental right, this right to know, is not a fundamental right. They have used the concept, they have used the word derivative fundamental right. It means that what the government has tried to project, that this 19(1)(a) is not 19(1)(a), which speak about freedom of speech and expression, nowhere prescribe, nowhere says that it also include right to know. So right to know is a basically act of judicial interpretation. It is derived by way of interpretation by judiciary. So it does not have the status of fundamental right. It is a category somewhere inferior to the fundamental rights. Now, the Supreme Court, while dealing with the objection, has held that, in fact, this scope of 33B is beyond the legislative competence of the legislature, because, again, the Supreme Court has said that this particular right to know, whatever has been held by in ADR matter, that right to know is a fundamental right. And it is the fundamental right of voters under Article 19(1)(a) of the Constitution of India. So any amendment which is made, any legislation which is made to control that particular right, that has to satisfy the restriction, that has to satisfy the criteria of restriction which is enumerated in Article 19(2) of the Constitution of India. So the Supreme Court has said that since the government or any of the parties representing respondent, they failed to brought out any reason satisfying the requirement of 19(2), therefore this particular provision 33B is in fact ultra vires, and it is said that it is beyond the legislative competence. Now, another aspect which the Supreme Court has dealt with, that whether the legislature can overturn the judgment of the Supreme Court which has been pronounced. And the Supreme Court has said that they can change it is within the legislative competence to change the basis of the judgment. It means that if a particular provision is being interpreted by Honorable Supreme Court and they make certain amendment, then definitely that interpretation does not hold any value anymore. But definitely they can change the basis of that particular judgment, but they cannot legislate to nullify the judgment. Here the basis of the Supreme Court has said that the basis of this particular judgment is not any legislation or representation of people. We have definitely interpreted Article 19(1)(a) of the Constitution of India, fundamental right, and it has been read as a fundamental right. So it is beyond their legislative competence that by way of legislation they control this particular right. Now, another aspect was dealt with by Supreme Court, that the argument that it is a derivative fundamental right means that by way of it has been derived by judicial interpretation. So the Supreme Court has very beautifully dealt with this argument and has said that, look, the Constitution is framed in such a manner that it has to be young and energetic for over a period of time. So there are broad ideas which are provided under the constitution, and every generation is required to substantiate that idea which is behind that particular constitution, behind with the framers of the constitution by giving this particular constitution. They have said that this fundamental right, the expression, freedom of speech and expression, or let's say any fundamental right, they are just like empty vessel. It's an empty pot where it is expected that every generation, from their experience, from their observation, they should pour something. So it's a freedom, that is right to know, is something which from our experience we have poured into that particular jar, so it has become part of fundamental right. There is no concept of this derivative fundamental right, because otherwise freedom of speech and expression is a vague term. It's not a definite that what would be covered. It is upon the judicial interpretation that what should be in it. Now, the another argument was that it would be violative of, they say that it would be violative of unnecessary violation of the privacy of a candidate, because you are asking for too many declarations. The court has dealt with that. There will be no violation of right to privacy of the candidate, because first thing we are talking about this criminal record, the pending trial. So the trial is always public, so everybody knows it. The second thing is education qualification. Education qualification is not something which is which the privacy which any candidate can claim privacy. And the third was that assets and liabilities. So the court has said that you are asking public to elect yourself. In any case, you are submitting ITRs, you are submitting these particular details to various authorities in various form. So it will not adversely affect the your right, and the citizen of the country, the voters of the country, has more sacrosanct right and more valuable right to know about you rather than your right to protect your privacy. Now, the court has said that 33B, with this discussion, the court has said that this section 33B do not pass as the constitutional validity, because first it imposes a blanket ban. It says that any other information is not required to be divulged. So it in fact restrict the power of the election commission to pass the instruction, the voters' fundamental right. So it does not pass that particular test. And secondly, it is blocking the information which is otherwise necessary and has been discussed by in the earlier judgment of Supreme Court. And the court has also dealt with this aspect that right to participate by casting vote at the time of election would be otherwise meaningless. If the voters are not well informed about the candidate, it would be just empty formalities, because there is no criteria left for them to make a choice about the candidate. They say that if we encourage this kind of suppression of information, the court has specifically observed this, and I am quoting that says that disinformation, misinformation, non-information all equally create an uninformed citizenry, which would finally make a democracy a mobocracy and a farce. So the court has observed that this particular, if we permit this, then it would not be a healthy democracy. The democracy will not function, because you cannot expect a voter to vote without having knowledge about the candidate. One of the argument was that this is 2003, and I failed to understand that what our politicians think. There was an argument that we do not have intelligent voters. So if the voters is not intelligent, what is the purpose? What would be the purpose? The court has said that this cannot be an excuse for not providing information. They say that the voter might be an illiterate. He is illiterate, but he or she is illiterate. But it does not mean that he or she do not understand the implication. If you make them aware about the candidate, the past of the candidate, the eligibility of that candidate, definitely they will make a right choice, and they will it will help them to arrive at a conclusion. So uh, they have drawn a distinction. The Supreme Court has ultimately drawn, for the first time, has drawn a distinction between right to vote and right to know. They say that right to vote is a your statutory right, but right to know is a fundamental right of a voter. So a voter can be prohibited for voting because of certain ineligibility, but so far as right to knowledge is concerned, his participation is concerned, that cannot be prohibited because it's part of fundamental right. Now there was another thing which the Supreme Court has dealt, though that was not an issue in this particular matter, because once ADR, the earlier judgment, that is Association for Democratic Republic judgment, was passed, the Election Commission has issued certain instruction, and one of the instruction was that if a candidate furnish a false information in this one other aspect I forgot to mention, that another argument was that though directions were provided, but if somebody do not comply with it, then there is no consequence provided. So there was certain correction which was made, and the Supreme Court has said that this should be in form of affidavit, and so that the legal recourse can be taken. Now, there was a direction by Election Commission in this case, when once the Association for Democratic Republic judgment was passed. There was a direction by Election Commission that affidavit should be filed, and during the time of scrutiny, once filed along with this nomination paper, and at the time of scrutiny of that nomination paper, if anybody found, if the returning officer holding a summary inquiry finds that there was a false declaration or there is a wrong declaration in that particular affidavit, then the nomination paper of that candidate can be rejected. The Supreme Court has said that no, this is because rejection of nomination paper is something which is provided by the statute, so it cannot be by way of instruction, and moreover, it cannot be done summarily also, because the candidate will not have a time to rebut that particular allegation with respect to that he has submitted a false, he has made a false averment in the affidavit. So this was in cooperation. There was a legislative change. Even the rules, the conduct of election rule, which are governing the election, they were changed. The rule 4A has been introduced. This form 26 was inserted in the rules, which prescribe the criteria upon which this declaration is required to be made. Now, definitely, though the politician says that this particular information is not relevant and the people will not understand, but they were very shy in making such kind of declaration. So what happened that instead of making any statement, once this in 2003 judgment, the Supreme Court has said that this cannot be a ground for rejection of nomination paper. It has provided a great relief to all political parties. So what they started, that they have the candidates started that if something is trouble in their history, something is they do not want to disclose, they kept the column blank. They have chose not to answer that particular column, or not to answer that particular entry. Now the returning officer, bound by that particular judgment, he felt helpless, and the things go on. Now here came in 2000, somewhere in 2012-13, there was another NGO, which is Resurgence India. What they have done, that in the year 2007 Punjab election, this NGO, because this affidavit is always placed in the website of Election Commission, and it's a public record. Even if you visit the website of Election Commission, you will find the affidavit from 2002 election up to the latest election. They are made available. So they have studied this 2007 Punjab election assembly election, and examined the affidavit filed by the candidate by 6 main political parties. Now they have found a mass scale irregularities. There were a number of blank columns. The informations were not duly provided. So they made a representation to the election commission saying that this particular area should be dealt with. Election commission promptly replied to their said representation and said that this PUCL judgment, 2003 judgment, which we have discussed this, they say that we cannot cancel the candidature or reject the candidature of candidate if he is not filling the form, filling all the columns. So we are helpless. So now this Resurgence India, they have filed a petition under Article 32 of the Constitution of India. Now here it is very interesting because initially we have seen it's a 226 petition before the High Court, because whether it is a fundamental right or not, it was a dicey situation. So what development we had the law has taken from 1975 to 2002, that it has crystallized the right to know as a fundamental right. So directly 32 petition was entertained because it's relating to breach of fundamental right. Now the election commission has supported that particular petition. The election commission has said that yes, we should be provided with some mechanism to deal with such kind of situation, because as we feel helpless in this. The stand of Union of India was again interesting, because I am referring to this particular stand because this reflects the mindset of our governing bodies. I'm not pointing toward any political parties. The person in power, definitely they are not in favor of disclosure. Any disclosure, because disclosure make them accountant and nobody wants to be accountable. So the stand of Union of India was that look, in PUCL 2003 judgment, it has already been held that wrong information cannot be a ground for rejection of nomination paper. And if it is not a ground for rejection of nomination paper, the same consequence, at max it would be a case of filing false affidavit, which the law take care of, particularly 125A of Representation of People Act, which provides for maximum 6-month punishment or fine. It is also punishment. It's a very small punishment. So they say that even this issue can be dealt. This case can be dealt as a wrong affidavit, and if anybody is aggrieved, definitely he or she can file a case before the competent court and get the person prosecuted for filing a wrong affidavit. Now the court has made analysis of the earlier judgment, made a provision RPN, and again has said that it is the first thing the court has said that look, the purpose of the affidavit, there is a RPA mandates certain qualification of a candidate to be eligible for election. Now the content of the affidavit is such, there are certain aspects of the affidavit which are such, which in fact enable the returning officer to judge the qualification of that particular candidate. But if you are leaving these columns blank, if you are not writing anything, then you are in fact virtually creating a situation where there is nothing for returning officer to adjust to decide about your eligibility. So there cannot be a blank column. And again, the court has said that right to know is a fundamental right. So you cannot be keep mum, because these are the area which are in your exclusive knowledge. So you have to make a statement on each and every column. There cannot be left to be blank. The court has made analysis of 2003 judgment and said that the logic behind 2003 judgment is that this particular nomination form cannot be rejected, because the inquiry before returning officers is a summary inquiry, and there is a handicap in the summary inquiry to actually find out the truth, because in the moment of election, the candidate who is leveled with allegation of wrong information in the affidavit, he or she will not get sufficient time to rebut that affidavit. So we never said that it is a blanket protection. In appropriate case, definitely the returning officer can reject the nomination paper. So the court has clarified it and said that it is the duty of the returning officer to ensure, to point out any candidate that your affidavit is having blank column. Sir, please make a statement. Either you have to write nil or not applicable or not known. It cannot be left blank. And even if after pointing that the candidate failed to cure that particular defect, then the nomination paper can be rejected. Now they say that so far as remedy under 125A is, the court said that 125A is for the offense for the non-disclosure for filing false affidavit. But if there is a violation of fundamental right, we cannot sit, and definitely that can be covered. Now, so the development of this right to know, so far as that is that there is a recognition of right and there is a mechanism provided for right. But till now, there was no mechanism, there was no effective mechanism to punish any candidate if he or she has failed to provide just and proper information in his affidavit, or he or she has provided wrong information or suppressed anything in the affidavit. That aspect has been dealt by Honorable Supreme Court in Krishnamurthy versus Shiv Kumar, that is 2015 volume 3, SCC 467. It is with respect to the municipal election of the local bodies, where the returned candidate, that is the candidate who has won the election, he has suppressed certain criminal cases. It is they were around 6 or 7 in number in his affidavit, which filed in support of nomination paper. So that was challenged after election. That was challenged by the other candidate, saying that since he has not provided true information in affidavit, so his nomination paper was liable to be rejected, and it ought to have been rejected. And in the light of this 2014 resurgence judgment, and the returning officer has committed an error in accepting that nomination paper. The trial court was district court in this case because it's municipal election. So the trial court has held that it is yes, it is wrong acceptance of nomination paper. So hold that the non-disclosure would entail rejection of nomination paper. This was challenged before the High Court. The High Court has agreed with the conclusion, but with slight modification. Instead of holding that it is in fact an offense which will entail rejection of nomination paper, the court has said that it will not be rejection of nomination paper, but it would be an undue influence. It would be a corrupt practice that is undue influence upon the voter, because criminal antecedents or criminal charges are something which is in exclusive knowledge of that particular candidate. Similar is that with the assets and other liabilities also. And if you're not coming up with the true statement for that, it would be amounting to the interference in the voter's choice, voters' capacity to judge, and voters to make a free and fair choice. And since it's a practice, it's a statement made by the candidate himself. Therefore, under the provisions of Representation of People Act, if any corrupt practice is committed by any candidate, then definitely his election shall be declared void, and the seat should be declared vacant. And this is a offense which is committed by the candidate, so it will definitely be corrupt practice by candidate, for which the election can be declared void. This matter traveled to Supreme Court, and the Supreme Court has also agreed to that particular finding. They have dealt with all the judgment which we have already discussed. They have dealt with the importance of right to know, and they said that if you are interfering in the voters' right to know, then definitely it would be corrupt practice, for which your election can be declared void, irrespective what suppression, what was the amount of suppression, and whether it has materially affected the election or not. So this particular aspect has been recognized as the electoral offense. And right to know is not only fundamental right, but interference with right to know was also recognized as electoral offense. So it has made a substantial change, because after that the politicians were very careful in making declaration, because they know that what would be the consequences for that. Now, if a mechanism is placed in 2002, there was a certain mechanism which was placed, and once a mechanism is what the Supreme Court has expressed in Association for Democratic Republic, when the politicians were saying that it will not have any impact. we have seen the effect of this particular disclosure in the year 2018, that is Lok Prahari judgment. Now, this Lok Prahari was an NGO which is basically having various intellectual groups like civil servants, retired civil servants as member. So they were working towards civil rights. So they have studied the various affidavits filed by the candidate, because after 2015 the candidates were very cautious in making disclosure. They were disclosing every property which is in their name, every source of income and other thing. So they have studied the affidavit and found a very interesting trend, that there are number of MPs and MLAs, though they were first time elected, but their income increased 5 times. More than 5 times in some cases, and they have substantially, and there is no visible source of income which can be reason for this particular increase. So they have filed a representation before Central Board of Direct Taxes, but nothing concrete. So they again file a petition. There were a number of prayers which with respect to, they have provided the list of the legislature, MPs and MLAs whose affidavit depicting such kind of irregularities. But there, one of the prayer which was seriously considered by Honorable Supreme Court is with respect to the suggestion in change in Form 26. Form 26 is the form prescribed by Election Commission for affidavit, that these are the heads under which the disclosure are made. And they said that this particular form should also make provision for disclosure of source of income, because if we don't know the source, then there cannot be a valid scrutiny. There was also prayer for amendment in the RPA and other, which has not been accepted by the Supreme Court. But so far as their first prayer is concerned, that has been seriously dealt, because Election Commission has also joined to the said request, and this Election Commission has said that we are also of the view that the source should be disclosed, because it will further purify the electoral process. So this particular aspect was examined by Supreme Court, since the right to know is a fundamental right. So said that even the source of income is very important, and this situation is very alarming. This particular situation is alarming, and this provisions is required to be made. Now, the court has dealt that there is no law dealing with periodic disclosure, but once you are submitting yourself for public scrutiny, public has definitely has a right to know about every aspect. So it is not the source of income, because the source of income, what is the source of your income, is very important criteria. The Supreme Court has said that to deal with this kind of problem, that increasing wealth, there are three solutions which we can deal. The first is that to make such accumulation of wealth as offense. The Supreme Court has said that we have already provision under Prevention of Corruption Act, so it is an offense. It is an offense if it is not properly acquired. Second is disqualification for re-election. The Supreme Court has dealt that again. The handicap is that disqualification cannot be prescribed by Supreme Court by exercising judicial power. So said that though it is desirable that there has to be committee which constantly monitor the financial affairs of the representative, but it is something which is in the realm of the governance and government. It is not for the court to do that. So that they said that we cannot definitely we can only make a request to the government, but we cannot prescribe it. The third solution which the Supreme Court has dealt with, making the electorate known about such accumulation and giving them choice. The court has very interestingly recognized this particular aspect. They have taken a judicial notice of this particular fact, that we are also observing that the income of these legislators are increasing manifold. They said that necessarily this is not a illegal means. There is also a category, a gray area, where by virtue of holding office, you can favor certain person, the person who are close to you, and that can be your source of income. Though it is strictly not an offense, but definitely it is morally not correct. So this particular thing, there is a way, one way which the Supreme Court itself has discussed, that if you are holding a key position in government, you can definitely secure a loan, a huge amount of loan for your any of relatives or any of associates, and that particular loan in low rate of interest, or another scheme, benefit of other scheme. So all these things, your source of income, your particular the income of your spouses and dependent children or another associates, that is equally relevant under this right to know concept. And this particular elaborate guidelines has been issued including this source of income in the disclosure clause. Now, the court has again warned the candidates that this disclosure is important, and if there is a non-disclosure, then it would be corrupt practice, relying upon 2015 Krishnamurthy judgment. Now, the final there is another small development in the year 2000, prior to 2018 election, in the matter of this public interest foundation and others versus Union of India. Now, it is again this NGO was also seeking a direction from Supreme Court that disqualification, it should be criminal background. Raising number of criminals in politics was a constant area of concern. Right from the 1990s, we are in 2009, 19, 20, 30 years, we are dealing with this issue. But they said that this criminalization, the person with criminal background, they should be disqualified from contesting election, because it goes against, it attacks on the very root of democracy, because lawbreaker cannot be a lawmaker. And there is an open affiliation of politicians, bureaucrats, and criminals, the person with shady backgrounds in politics, and this is visible and nobody is doing anything. So the Supreme Court should step in. Now the Supreme Court again has felt certain handicap. It has recognized this, but it has in fact echoed with the submission made with respect to the criminalization of politics. But again said that this is something which disqualification is something which is not our area which we can prescribe for. We cannot suggest any amendment. We cannot compel the government to legislate. But definitely, again, right to know and 324, Article 324, that is direction of Election Commission, that is a power of Election Commission to supervise the election. That came in rescue. Again, the Supreme Court, Honorable Supreme Court, has interpreted this in favor of disclosure, and they said that what best we can do is that this particular thing, this disclosure should be very proactive. So they issue direction that Form 26, you are required to fill Form 26, but and every particulars are required to be filled, but information with respect to the criminal cases, that has to be filled in bold and highlighted, so that it attracts the attention of people, attention of voters. The second thing is that if a candidate is contesting from political party, because there is an allegation with respect to the nexus of political party with the criminals and encouraging these kind of person, and then if a candidate is contesting election in a ticket from political party, then she is required to inform that political party about his criminal antecedents and pending criminal cases, and this political party is required to furnish a statement and place that statement in their official website, so that the people can access. Definitely, the idea is that this will have a certain deterrent effect on the political parties, because this will be the statistics which will be echoed in all the news channel, and it will give, to some extent, it will give a negative publicity and somehow discourage it. Third is that wide publication of this information, if you happen to see all Form 26 from 2002 onward, you can also find out that what are the gradual changes and how it is classified, how it is made more clear. Now the present Form 26 have the detailed heads of the information, and thereafter there is summary of the information, so that if somebody is not interested in detail, he or she can have summary. So this summary of cases and this particular thing that is required to be widely published in newspaper and electronic media, and at least 3 times after filing nomination, and that this particular election commission has taken care of this particular thing, that they have issued, they provide the list of the newspaper and news channels in which this particular publication is made. So if a particular candidate is having criminal background, that definitely he or she is required to make publicity of that thing, and this is done to protect this voter right to, a right to know. And the basic purpose of this particular publication is to inform the voters so that the voters can make a right choice. So friends, we have seen that how this concept has been conceived in 1975 as a concept, 2002 with Association for Democratic Reform cases. It has been delivered. It has been delivered, actually substantially delivered, and thereafter the subsequent judgment has made it more strength. So to me, this right to consent, right to know, has been particularly in democratic process in election with respect to the background of the candidate, that has developed much by the Supreme Court, though there are many things which are still required to be done. Thank you.
I think that was a very enlightening and enriching session. The audience has loved you, sir, throughout the course of the session. Of course, there have been many questions coming in from the audience, and I think we could directly move towards the questionnaire session.
Sure.
We have the first question coming in from Achyutendra. He says that currently the names of the COVID-19 patients are not disclosed publicly by the administration. What is your view on this? Is it in protection of the right to privacy? He has also made an addition to this question, or the public has a right to know the name of the patients to be aware about the infected persons and areas.
Now, it is a very difficult question to answer, because whenever there is a fundamental right, any right has corresponding duty and obligation, and basically it is a perfect balance is required to be drawn. What I feel, that what is the reason for non-disclosure is to encourage the people to come up with their symptoms, and to have a maximum disclosure about that particular symptoms, because what it is in the opinion of the government, that that if we protect the privacy of the person, because what we have seen, if you have experience about this particular thing, then you see that there is a discrimination. The society is divided between two kind of person, the COVID positive and COVID negative. The society has a very strange reaction. So to control this kind of reaction, the government has to take this particular measure. And in any case, if you see the law governing privacy, medical record is something which is a private affair, and which is always protected. We have a celebrated judgment of Mr. X versus Hospital Z. It's with respect to the AIDS patient. The similar case, same is required. A doctor is not expected, or anybody having a knowledge about the medical condition of person is not expected to disclose it in public. It is only when the right to privacy overweight the public right to know, that is only the criteria for disclosure. Here the government and even the court, in some cases this order has been challenged, and the court has favored in towards non-disclosure, because they feel that it is much in the interest of controlling this pandemic not to disclose the name and identity of the persons, to encourage them to report the symptoms.
Thank you, sir. I think we have the next question coming in from Mahesh Jain. May the Public Information Officer fix particular days in a month for the inspection of records under the RTI Act of the 2005?
Actually, if you have gone through RTI Act make a provision with respect to disclosure of general information. There is a provision in the RTI Act which says that in the official website, the routine business of that particular government or authority should be made available in the official website. So you need not to visit to that particular. But I think that instead of having particular day or month for inspection, if you apply for inspection, because RTI Act also provides for inspection, where you can apply to a public authority that I want to inspect a record, and they will provide you a date and time when you can inspect it. Definitely, you can do it, because it will be more fruitful if you have a specific if the authority is having a specific information that what would be the subject matter of inspection, what is the record which is going to inspect. Otherwise, in my opinion, it would be create a difficult situation, because at that day would be the holiday for that office, because record would be open for inspection. Anybody. So it would not be, in my opinion, in uh, what I feel that this would not be interest. Better course would be make an application to the authority for inspection of record and go for it.
Thank you, sir. We have the next question from Mirza Muhyiddin Beg. He particularly questions about the PM Care Fund, wherein the received amount is not usually shown out to the audience, and he says, "Isn't this a violation to the right, as common citizens have funded it and they have the right to know?"
Definitely, it is settled proposition of law that the government should come up with the maximum disclosure. So, uh, what is the rationale behind non-disclosure? The government failed to disclose it also. So, in my opinion, definitely the person have a legal right. Particularly, they have if you're receiving fund from public, then and that too for dealing with the pandemic, I see no harm in disclosure of their details, because in fact disclosure will encourage donation, because if I know that where it has been used, I would be know I can relate myself with donation, and it will encourage public to donate more. So from legal point of view and from also administrative point of view, in my opinion, the disclosure should be made.
We have the next question from Varsha Kumari. In this situation, like the pandemic COVID-19, patients are being charged very heavily by the hospitals for the treatment. Can the Honorable Supreme Court of the High Court initiate suo motu against such hospitals, as this is shown publicly by the media?
Power is already there, but the difficulty is that in case of suo motu proceeding, the court act as a prosecutor. The role of the court more become prosecutor, and in fact, it is for the government, because it is a very this particular area is very problematic, because it came in direct conflict with the uh, jurisdiction of executive, because controlling the price of a drug or controlling the price of a service is a more of executive function, and it requires different kind of expertise, and without having that expertise entering into that area would be a problematic, but we might end up scarcity of availability of these resources. So if a balance is required to be drawn, it would be best course either some PIL is filed, or there should be a prosecutor, and the defense at the court should better act as an adjudicator, because suo motu petition is always discouraged in legal arena, because there the court to some extent act as a prosecutor. So unless and until it is exceptional circumstances are warranted, the court always refrain from taking suo motu cognizance of the matter.
I think with this we can take the last question for today evening. The PMO has claimed that the PM Care doesn't come under the ambit or the purview of the Right to Information Act 2005, and has taken a stance that it needn't respond to petitions under the same. She makes a continuation to the same, considering that PM Cares is basically public money meant for the welfare of the public. Isn't this behavior of the central government a violation of the freedom of speech and expression as per Article 19A?
This particular, because there are two aspects of this particular question, is that the first is that right to know, that whether a person is having a right to know that particular, because if you are alleging a violation of any right, then in order to seek any relief from court, there has to be corresponding injury. You have to demonstrate, because the court always refrain adjudication of an issue without consequential injury. Now, this particular right to information, this particular dispute, definitely it's a reply by one of the authority by this public information officer, which is called, it would be subject to challenge before the state or central information commission, and would be first it would be challenged before the appellate authority, and thereafter it would be challenged before the state or central information commission. Since I am not aware about the actual facts of this particular the grounds, I have not examined this particular reply of the PM of the office which is governing PM Care Fund. So I feel handicapped. But if it is a public authority, if it has government functionaries, if it is performing certain statutory function or the function of the government, then definitely that will fall in the definition of public authority, and that reply would not be proper. But it's too premature to make any comment upon that. That is subject to the examination of record.
I think with this we come to the end of the session, sir. I would really like to apologize to the audience that we could not accommodate all the questions due to the paucity of time. I would really like to express my gratitude to sir for joining us today evening. Thank you so much, sir, for being here with us. The audience has really loved you throughout the course of the session.
Thank you very much.
I also take this opportunity to introduce the next edition of the webinar, which is being organized in collaboration with Association for Democratic Reforms, which Sir, I think, mentioned throughout the course of this session. To register for this session, log on to www.lawessential.com. Thank you so much, everyone, for attending.
Thank you very much.